Yes, Mr.
Well,
Alexander.
just a few points. First, in relation to the Court of Appeal skeletons, we're getting hold of those and we'll file them.
Thank you very much.
There are extracts in bundles already, and on one of the points, perhaps I can just draw my Lord's attention to page 491 of the electronic bundle, which is Interdigital's skeleton for the Court of Appeal, paragraph 14. We refer to this in our skeleton on the procedural context as to what was debated and not debated below.
Sorry, paragraph?
Paragraph 14.
14.
And what was said there is, IDG does not say Tesla's case on this is unarguable at the serious issue to be tried level for the purposes of jurisdiction, but the point would be disputed on the merits. This is the point of principle as to whether the platform license must be FRAND. So we say that at least that point was accepted to be arguable by Interdigital at this stage, although obviously they contest that that's the case.
Can I just have the reference again? Sorry.
I'm sorry, my Lord. It's page 491. And it's paragraph 14.
Thank you.
The point is at the final sentence of that paragraph. And I think, having looked at this again over the adjournment, it's fair to say that Avansi's position is not as clear on that. We put in our written case that Avansi likewise proposed the issue of whether the SEP owners' FRAND commitments were discharged by the availability of bilateral licenses alone, such that the Avansi 5G pool license need not be FRAND, should be heard in a gating trial following the jurisdictional dispute. In a sense, that implicitly accepts that there's an issue there. But I don't think it's fair to say that they were as unequivocal on at least serious issue.
And sorry, the page reference for that last one was?
The page reference for that last one is in our written case at page 34, paragraph 17.
Right. And
it's then cross-referred to part of the evidence, which is at page 583, which is Ms. Regendera's statement relating to the procedure.
Yes.
But ultimately, we don't say that this case will go on who accepted what.
No.
At any given stage. But I just wanted my Lords to be clear about what was clear and what was not clear.
Yes.
The only other point that's left for me to deal with is ground 3. Ground 3 is very much a tail-end Charlie. And what that is about is the position in relation to this claim. If you are against us in relation to the platform license. Because we say, well, if that's the case and we need to get an individual license, then there is utility in the court in determining this matter. We have put our argument rather briefly in relation to this in paragraphs 54 to 57 of our written case. That's pages 43 to 44 of the electronic bundle. And we don't really think we need to add anything to the points made by Lord Justice Arnold, which we respectfully submit are to be preferred in relation to this matter, and the reason being that if it's right that there isn't a case to be advanced in relation to the Avansi license, then essentially one would need to determine what the terms were of a bilateral license. But the majority of the Court of Appeal was, of course, right to say that's not really what this case is about.
There's no dispute about that, is there? There's no dispute about entitlement to a bilateral license on FRAND terms as such.
No, there's no dispute to that, but there would be likely to be a dispute as to what those FRAND terms were. That's the utility of that.
I understand.
But I can't say that is a major part of the case. Obviously, we're here in relation, in some sense, to the point of principle and the point of determination of the Avanci license, but I just wouldn't want to have not said anything about it.
Yes,
So,
very much.
unless you have further questions, those are our submissions in relation to grounds 1 and 2 and the correlate
Yes.
cross appeal.
Thank you, Mr. Alexander. So, Mr. Vickerdopoulos.
My Lords, I'm addressing you on the jurisdictional issues that have been raised by Interdigital in grounds 2 to 4 of their notice of intention to participate, and Forum, which is raised by our ground 5 and also raised by both Interdigital and Avanci. And I intend to structure my submissions this afternoon into 5 parts, divide them into 5 parts. The first is to make some introductory comments on the basis of a claim such as this, how it arises, and how that then you see in the particulars of claim. Second, I will turn to Gateway 11, which we say applies to all respondents. Third, 6314, that's CPR 6314, which we say applies and permits service in the jurisdiction on the second respondent, IDPH, who is the patentee, and then Gateway 3 for the other respondents. Fourth, it's the issue of forum, which includes within it characterization of the claim, whether Delaware is an available forum, and if it is an available forum, whether it is clearly or distinctly appropriate. And finally, fifthly, there are 2 procedure objections, which I will briefly turn to at the end, one by Interdigital in respect of Gateway 11, and one by Avanci in relation to Gateway 3. So turning to the first part, which is the basis of a claim such as this, and what we say the court is being asked to resolve. And we say at the heart of the claim is a claim by Tesla that it is entitled to be granted a FRAND licence under the UKSC and for a declaration of the terms of such a licence. And as I'll show you, that Tesla's pleading explains that Tesla wants to launch 5G-enabled vehicles on the UK market. But the UK market is its 4th largest global market. But in order to do so, it must, of course, use 5G technology, which is protected by the UKSC, owned or licensed by the respondents. Now, my learned friends point out that Tesla is a global company that sells vehicles all over the world and will also like a license in other countries. And we say that is true, but does not detract from the fact that the claim concerns Tesla's desire to obtain commercial certainty in this market to launch its 5G-enabled vehicles. Now, my lords would appreciate that ordinarily a person launching what are going to be infringing products onto the UK market has no right to a license from a patentee. But the reason Tesla says it has such a right arises because the patents in issue have been declared to be essential to the 5G standard, and as my learned friend Mr. Alexander submitted this morning, those who declare their patents to ETSI give an undertaking that they're prepared to grant licenses on FRAND terms in respect of those patent rights. And it was held by this court in On My Planet that this ETSI declaration forms a French law contract between a SEP owner and ETSI for the benefit of third-party implementers, which can be enforced by those third-party implementers. And this court held that the obligation is global, in the sense it attaches to all SEPs in a declared family anywhere in the world. And, of course, the courts held that often, if not always, in a case such as the present, the only FRAND licence is likely to be a global licence, and that is because of the inefficiencies inherent in national licensing. But the court also made very clear that the English court, when determining such terms, is not determining the terms to be paid under foreign patent rights, and nor is it extending impermissibly its jurisdiction. The claim concerns UK patent rights, and to understand that, it's important to understand that it engages two elements which interrelate with each other. The first element is the property right. And the property right is the UK SEP, or SEPs, in respect of which a license is needed so that an implementer can practice the standard on the UK market without hindrance. Without a license to those UK property rights, no implementer can access that standard lawfully in the UK, assuming the patents are indeed standard essential patents. The second element, which we say overlays the national patent rights and attaches to them, is the undertaking the owner has given in respect of those rights to ETSI to grant the licenses on FRAN terms. And although that is a global undertaking, this claim concerns enforcing that undertaking in the UK to obtain a license to the UK rights that are subject to it. And of course, to determine that will require a determination of what is FRAND. And as I've said, in this court in Unwire Planet explained that that is a factual question which is informed by practices in the industry to help determine what willing licensors and willing licensees would agree is FRAND. And as my lords will remember or know, the evidence in Unwire Planet at first instance before Mr. Justice Burse, as he then was that almost all of the licenses to cellular SEPs that were freely negotiated in the evidence were global, potentially with a country carve-out sometimes for a specific country, such as China, but none was national. And that forms the basis of the finding that in the cellular space, the likely FRAND license is global in scope, and as my lords know, the only license on offer from Avanci is indeed global in scope. So that is the license the SEP owner must offer in respect of the UK patents, if that is FRAND, and the implementer must agree to enter it to avoid the consequences of UK infringement. But the other point that was made clear in Unwired Planet is that if a SEP owner does not offer the license the court has held is FRAND, then that has consequences on the SEP owner as well, and most notably an inability to obtain injunctive relief if they refuse to offer the license that the court has held is FRAND.
Does not the underlying patent then get taken out of the standard, or is there a risk that it does?
I don't think that has gone as far as that, as to know whether ETSI would take it out of the standard. My lord, at the moment in Unwire Planet, what was held was if the SEP owner refuses to grant the license, then the impact is an inability to enforce it, at least in this country. Right. It didn't go as far. The Court of Appeal nor the Supreme Court went as far as to say it should be removed from the standard by ETSI. I understand the force of my lord's point, but that has not been to date what has been held by the courts.
Mr. Nicholas, do I correctly understand that in Unwired Planet there was no suggestion that the only FRAND licence would be a pool licence or a platform licence?
The question didn't arise, I don't think, in Unwired Planet, because Unwired Planet was a bilateral licence from Unwired Planet to Huawei, and no question arose over pool licensing, to my recollection. And so the only question in that case was, what was the scope of license that Unwired Planet had to grant? And then, of course, there was a dispute over the terms and rates of that license.
There was no discussion of pool or FRAND, pool or platform licensing in that case at all?
I don't think so. I can have that checked by someone around me, but I'm fairly sure, my lord, that there was no discussion.
Thank you.
I think it was a group of patents owned by a particular proprietor, and the issue was on what terms would that group of patents be licensed?
It was in the sense of a group of patents in that it was patents globally owned, They were patents that had originally been owned by the Ericsson portfolio, and they had been divested to On My Planet.
Yeah.
They were owned by On My Planet, but they weren't
Not
all
it
over the world.
It wasn't a pool in the sense
wasn't a
or
pool.
platform in the sense we're talking about either of those terms.
That's right, my lord. It was owned by On My Planet. On My Planet said it wished to grant a global license to its portfolio. Huawei, the implementer, said that it should only be a UK-only license, and then the argument arose as whether or not, by Mr. Justice Burse granting or settling the terms of a global license, whether that impermissibly encroached on comity and in particular in that case China, with Huawei saying its business was centred in China, its manufacturing was in China, and most of its sales were in China, and not here in the United Kingdom.
Thank you.
And as I say, Mr. Justice Burse, as he then was, made clear, and that was upheld, that that's not what he was doing. He was looking at the FRAND obligation, saying the obligation is to grant, is met by a global license, and that then applies to the UK patents. My lord, since On My Planet, and On My Planet was a case, as I just discussed, brought by a SEP owner for infringement of UK patents, and FRAND was raised as a defence to injunction by the implementer. Since then, the courts have made clear in cases such as Interdigital and Lenovo that implementers should seek licenses at the earliest opportunity or face potentially substantial negative consequences in terms of past royalties, interest, and of course injunction if they do not. And as part of that, implementer-led claims, as they can be referred to, such as the one before you today, have arisen where implementers don't wait to be sued and then raise a FRAND as a defence. They proactively bring a claim for a right to a licence under the UK SEPs in order to avoid any consequences of infringement and to try to obtain commercial certainty for their UK operations. And the first of those was a case called Kaijen and Thales, which was before Mr. Justice Fancourt. And a number of them have since arisen and have gone through and are going through the courts at the moment. And we don't need to go to it, but Lord Justice Arnold explained the basis of an implementer-led case in Panasonic and Xiaomi, which is in the authorities bundle at page 2658 at paragraph 15. And essentially what he says is that implementers can bring a claim of right if they commit to take the determined licence. One of the issues in the Kaijen case was whether the person the claimant had committed. So my lords will find that in paragraph 15 of Panasonic and Xiaomi. And as I'll come to, the reference to bringing a claim of right also arose in the Vestel case, which Mr. Alexander took you to this morning, where one of the problems in that case was that the implementer had not alleged a claim of right. And that mattered particularly in that case because that was under a different obligation, the ITUT obligation, and needed to be pleaded. I will show you that in a moment. Now, on this appeal, the respondents do not appear to dispute the logic that if the ETSI undertaking is enforceable by implementers by way of defence, it is enforceable by way of self-standing claim. They say the jurisdictional consequences that flow from that differ. And we disagree, but before turning to that, it is important on a jurisdiction challenge in our submission just to see how the particulars of claim reflect the two elements of a claim such as this that I have discussed. And if I may, just to go to the particulars of claim, and they are in the main hearing bundle and start on page 954. But we can pick it up on 955. I should say I'm taking you to draft amended particulars of claim. They haven't actually been amended yet, but the reason I'm taking you to this version is they remove and have deleted some points that are no longer advanced, and it avoids confusion as to what is in and what is not. And at 955, one sees from paragraphs 3 through to 10 that the link with the UK and why the claim is being brought in the United Kingdom is set out. At paragraph 3, it's explained there's the risk in that it talks about how Tesla does not accept the pool rates for 5G, and it also points out and pleads that when the last dispute happened under 4G, it exposed Tesla to injunction risk, and later in the pleading it sets out the injunctions that were sought. And at 4, at the bottom of paragraph 4, it pleads what I have submitted to you, that what Tesla wants is to be able to future-proof its vehicles in anticipation of the eventual phase-out of the 4G network. So it wishes to bring in 5G capability in the anticipation that 4G will stop being supported. And at 5, we have the claim of right, that we have a claim to enforce the contractual entitlement to FRAND terms. And between 8 and 10, it pleads the importance of the United Kingdom for this. It pleads there that it's the 4th largest national market by volume for such vehicles. And at 10, you can see the amount at the bottom of paragraph 10, which the UK company's business has in revenue, and on any view, a very substantial UK business is pleaded. Turning to page 959, the pleading then traverses some of the points that were being discussed this morning with my learned friend Mr. Alexander about the relationship between Avanci and the Avanci pool members, and you see in 21A that Avanci is a licensing agent. And obviously I will not go through all of this, but one point to pick up one sees at 25A is that it is pleaded that the provisions of the agreement that Avanci has with pool members means that pool members will recover from Avanci litigation costs of suing if that is deemed to be an unwilling licensee. So there's the importance of Avanci and its position in the dispute is pleaded. And then, but under the heading commercial relationship between the parties, I won't go through it all now, but this is where it's pleaded that at the last round of negotiations on the 4G license, Tesla was on the receiving end of a number of patent infringement proceedings from a number of members of the Avanci pool, and that is then over a number of pages set out. At 964, the challenged patents are set out, and as my Lord Kitchen explained this morning, there are 3 of those, which you see on page 965. And then at 966 comes the pleading as to the FRAND commitment and the entitlement, and at paragraph 40, you see that is directed to Digital. Tesla says it's a beneficiary of Interdigital's FRAND commitment, to be entitled to a license on FRAND terms, and at the end it wants such a license by the time that it begins to sell 5G-enabled vehicles in the United Kingdom. And at paragraph 41, a similar plea is made to be a beneficiary of all the Avanci 5G pool members, including Interdigital. And at 42 is the point pleaded here that trying to approach each one for bilateral licenses would be impractical and onerous for Tesla. You see that on the 3rd line of paragraph 42. In accordance with the what is FRAND, then in 42 it is pleaded that the FRAND license to the UK SEPs would indeed be worldwide, would include all the patents that are relevant in the Avanci 5G pool, and would have a lower rate than Avanci are requiring. So that is a pleading on the license. Then the pleading then goes to the FRAND commitment, and just to pick up 2 points on that, on page 970, paragraph 53, you will see it is pleaded that the construction, validity and performance of the IPR policy is governed by French law. And at 56, it's pleaded that as a matter of French law, the FRAND commitment is to be performed in good faith, and that requires a SEP holder, over the page on 971, to have regard to legitimate interests and concerns of licensees and not to seek to procure illegitimate advantage, in effect going to what Mr. Alexander said this morning about avoiding hold-up. And at 58, you'll see then a pleading against Avanci that they have been appointed as a licensing agent to enter into and grant licenses, and Tesla is entitled to enforce the FRAND commitment on each Avanci 5G member, including Interdigital, and so that the overall license that is offered by Avanci must be FRAND. Finally, loss and damage at 60. This goes back to the purpose of the action, to get commercial certainty on the UK market. And you see there it's pleaded that if this court will determine terms are FRAND for a licence, and Tesla thereafter can ensure that it is required only to pay such sums as would be FRAND and would avoid the consequences which would otherwise result were such a FRAND licence not to be available on commencing importation of 5G vehicles into the United Kingdom. And those consequences obviously can be anything from super-FRAND rates to injunctions. On the claims, we only need to look at one of those, I think, for now. At 5, it matches what I have shown you and what has been pleaded, a declaration that the Avanci licence, insofar as it relates to any patents in the pool which designate the United Kingdom, is not FRAND. And then the alternative is actually what might be called a rate-setting request, a declaration as to the terms which are FRAND for those patents, so those are the ones in the United Kingdom, alternatively such patents within that pool which are owned by Interdigital. Now
I'm slightly puzzled by them being put that way round in Prayer 5. I'd rather assume that what you really want is a declaration of terms which are FRAND, but falling back on a non-FRAND declaration in relation to the 5G pool in the alternative.
My Lord may be right. I think the reason is that the first declaration is have they met, in one sense, have they met their obligation already? And the second, if they haven't, what should they do? And sometimes
so it's not really an alternative. And if so, we want this one too.
It's an alternative, I suppose, in the sense that if in fact the court held that the Avanci offer is FRAND, then one wouldn't go any further. Sure. And if it holds it's not, then we would like the court to determine the terms that are. So it may be right that alternative may be not quite the right word. But so we say that pleading fits and matches the approach I have outlined in my submission for pleadings of this kind. And it serves a useful purpose for the reasons that Mr. Alexander has explained, and I will not go over. I will say that the focus is commercial certainty for the UK launch of 5G-enabled vehicles and getting a licence under the UK rights that would otherwise prevent that. With that introduction, turning to the second part of my submissions, which is Gateway 11, because it is said against us that this claim cannot pass through at Gateway 11. And to pass Gateway 11, the claim must relate wholly or principally to property within the jurisdiction. And the issue arises because the respondents say that the vast majority of the patents in the Avanci 5G pool are not UK patents, and they would be covered by a global licence. And so they say the claim does not meet the requirement for wholly or principally property within the jurisdiction. And we say the answer comes back to the two elements of the claim that I have addressed you on. It's the first element that relates to the property, and the only property at issue is the UKSC, that's on our planet, and that is wholly within the jurisdiction. The second element is not property, it's the undertaking that attaches to that property to grant licenses on FRAND terms in respect of that property. And if the only licence on offer, or if the court holds the only licence likely to be FRAND is a global licence, we say that does not alter the fact that the only property at issue is the UK SEPS. And for that, we rely on the obiter findings of both Lord Justice Burse in Vestel and Lord Justice Arnold in the judgment under appeal, and also in the way it was described by Mr. Justice Zaccaroli, as he then was, in Alcatel, which we commend, but with respect. And if I may show you that reasoning briefly, some of it is set out in Lord Justice Arnold's judgment, but if I could take it from Vestel, which is in Authorities, page 3046. Authorities 3046. As I think Mr. Alexander explained, this was a claim by a Turkish television manufacturer for a license under the video compression standards, which are not operated by ETSI, but they're operated by the ITUT in Switzerland, which has a similar obligation to grant licenses on RAND terms rather than FRAND, but nothing turns on that today, nor does the difference in Swiss or French law matter for today. Vestel was seeking a declaration of RAND terms from Access Advance, which is the pool license operator in video compression, or one of them. And a question arose over whether there was a serious question to be tried. Now, or whether a claim had properly been made. The question of whether or not there's a serious question against pool administrators did not arise in this case. So although this was a pool administrator, the point before my lords did not arise. What happened is the claim started as a competition claim alleging an abuse of a dominant position by Access Advance, the pool administrator, and another SEP owner, Phillips. That failed, and when it got to the Court of Appeal, the competition claim had been dropped, but the problem for Vestel was that nothing had been pleaded in its place, and that omission was pointed out by Lord Justice Burse on page 3051. At paragraph 34. Where he says notable by its absence is a claim it has a legal enforceable right to a FRAND licence. And of course this was not an ETSI case, it was an ITUT case under different law. For that reason, the discussion on Gateway 11 is obiter, but we rely on it and commend it with respect as correct. And that you can pick up, my lords, at 3055, page 3055. And at paragraph 66, Lord Justice Burse describes how Vestel were now putting the case, which is the claim was for a declaration of what the FRAND terms should be for a licence under the UK SEPS. That claim can be brought under the court's inherent jurisdiction. It would serve a useful purpose, and it establishes what they wouldn't infringe and what they need to pay. As I've shown you, they hadn't pleaded sufficient amounts. But what he did say in relation to Gateway 11, if my lords would read paragraph 71 at the bottom of 3055.
As I understand it, the case you have to meet really is focused on the last sentence of that, and whether that is correct in circumstances where your case, as I understand it, is that only a worldwide Avanci license under the platform is going to meet the FRAND commitment.
Indeed, my lord, and we say we do meet that because because the property right is the patents, and the license that attaches to those patents may be FRAND, and it may be the only one that is FRAND, and we plead that it is, a global one is FRAND. And we say that is the correct scope. But as I'll show you, what one mustn't confuse, and this is what Mr. Justice Zaccaroli explained, was the subject matter of the claim, which is the property in the jurisdiction, and the licence and relief that arises from that claim. And so we say, that is what we say Lord Justice Burse is saying here, where he says that it doesn't affect the matter even if 5% or less of the patents of the whole global portfolio are in the UK. They are the ones which the court is considering, and those are the ones to which the FRAND licence attaches. And the fact that its scope may be broader than the UK does not affect that it's a licence to UK property. And I've raised Mr. Justice Zaccaroli's, as he then was, summary of that, which one finds in the authorities on page 1326.
This is Alcatel, isn't it?
This is Alcatel.
Yeah.
And the way the learned judge in Alcatel put it, you see in paragraph 120, where he says the obiter comments of Lord Justice Burse is correct. Nokia's argument confuses the subject matter of the licence that is sought with the subject matter of the claim that is brought. The claim is one to enforce the contractual obligation of Nokia, pursuant to the declarations made in respect of 2 UK patents, to grant a licence on RAND terms. That is a claim that relates wholly to property within the jurisdiction, even though the licence sought is one that covers a global portfolio of patents, of which the UK is only a small element. And,
apart from him saying that Lord Justice Burse is correct, what does Mr. Justice Zaccaroli add to the sum total of legal knowledge on this subject?
I mean, no disrespect to Mr. It was a way of encapsulating the issue, but my Lord may be right. It encapsulates the issue of not to confuse the subject matter of the claim brought with the licence sought. And we say that is the correct analysis, and the claim brought relates to the UK patents. And that is also why, under On One Planet, when the court does this, it is not setting licence terms for foreign patents, it is setting licence terms for UK patent. And so we say it is the correct analysis.
Well, with respect, is that as a matter of substance, what your clients want is a worldwide licence under all the SEPs on the platform, and that will cover the United Kingdom. But in substance, are your clients not seeking the worldwide licence under the Avanci platform, because that is the only way, realistically, you can secure the licence under all the various rights held by all the different members of the platform?
Well, my Lord, we say as a matter of, firstly, as a matter of substance, as I've shown you, we want a licence to launch cars in the United Kingdom. My Lord is absolutely right that we'd also want a licence going broader than that. But this claim is directed to the United Kingdom. If the only licence on offer, as it is a global one, that doesn't mean it's no longer a claim relating to patents to the United Kingdom. That's the one that's on offer, or it may be on the evidence that is what's found. But my clients, otherwise it's another way of saying that my clients can't bring an action for a licence under, for instance, Gateway 11, to a licence to UK patents or UK SEPs, when the implementer, SEP owner, says, well, sorry, only global's on offer. And we say that can't be right. And so it is important to keep the two, we say, apart, in that the licence we want in this claim is a licence to the UK. But my Lord is right, plainly, we're a global company. But we say that doesn't alter the analysis on Gateway 11.
But Gateway 11 requires it to be wholly or principally
That's right.
property in the jurisdiction. I can quite see that if you separate out 5% of the patents over which you're seeking a licence, and say if you just look at those, that test is satisfied. But why should one just look at those?
Because those are the ones on which the licence has been requested. So we're requesting a licence to UK SEPs, just as, for instance, in Our Planet, the licence that was under consideration was the UK SEPs alleged to be infringed by Our Planet. That's a different question to what the scope of the FRAND obligation means that licence has to be.
Yes.
And the scope is that may be broader. Here it's global. But that's the scope of the licence, not the patents which we're requesting a licence for. And as I say, the patents that we want a licence for in this claim are the UK patents. Now, the scope that's FRAND may be larger.
I certainly understand the way you framed your case, but one can't stop but think that it may have been that if all your clients wanted was a licence under the UK SEPs, they could have asked for one.
Well, at the moment, I think the evidence is that Avanci has basically said nothing is open for negotiation. In fact, Avanci says it can't negotiate.
No, from Interdigital.
Interdigital, my lord's right, one could have asked for... but as we know from Our Planet, that they are likely to be able to say that a global licence is FRAND and a national licence is not. And that gets you back to a situation where it's very hard then for an implementer, if it wants a licence to the UK, and it wants to fourth largest market, that could be ended, as my learned friends say, won't get through the gateways, if they say, well, in this market, only FRAND licences are global. The only FRAND licence is a global one. And that comes back to the point that the licence is about a UK patents to launch in the UK market.
Thank you.
And the scope of that licence is a different point. It doesn't relate to the property. The property is the UK patents. And that's what we need. It's the UK patents that we need in order to be able to launch in the UK.
You've identified 3 interdigital patents. And to get a licence under those, you would prefer to go through Avanci and seek a global licence of all the SEPs, of all SEP holders.
The 3 are identified, my lord is correct. In pleadings of these implementer-led patents, often 3 are identified almost exemplars of the UK because they are standard essential. So if they are standard essential, then one infringes them. And a different patent doesn't give a different answer to that. And then within that, one wants a licence to the UK market. My lord, the licence that is on offer from Avanci and is often held to be FRAND, or universally held to be FRAND in these cases, is a global licence. But I think, my lord, we're sort of going around
Indeed.
On that one.
Thank you.
We say it is... The basis of this reasoning was also the reasoning of Lord Justice Arnold in the present case, and one sees that in his judgment at paragraphs 108 to 109. Page 265 of the core bundle. And at 109, he makes the point that whilst the argument that the reality, the claim on Tesla's own case is a contractual claim to a global licence, the vast majority of which are non-UK SEPs, it says that has a superficial attraction, but doesn't accept it for reasons he sets out there. In short, it's necessary to distinguish between the property on the one hand and the FRAND obligation which affects it on the other. And he makes the point that I've submitted, that the patents are territorial, and it's the UK patent, and thus a licence to a single UK SEP on FRAND terms can be, and often is, global, and indeed other families and SEPs in the entire portfolio. And he concludes by saying that the licensing claim therefore relates wholly to UK SEPs, even though our case is that it can be the licence scope of the obligation to grant may be of a global scope. Now, we say when properly assessed, we commend that reasoning to the court. My Lords, a slightly different point then arise for the third part of my submissions, which is CPR 6314, because that permits service on a proprietor for proceedings that are relating to a patent. So that does not have the wording that we've just been discussing on wholly or principally. My Lords, we'll find CPR 6314, I'm not sure we need to turn it up, but it's in the authorities bundle at 1064, and it permits service of a claim form on the registered proprietor of a registered right, which includes patents, of proceedings that are relating to that registered right. Now here, the registered proprietor of the specific patents is IDPH, and it has registered a UK address for service in respect of its patents, and it's registered that at the UK Patent Office. And we say that engages 6314 because 6314, as I've said, if you have given a UK address for service, that is, it's permissible to serve proceedings on that address for service if it's relating to the registered right. And the issue on this appeal is whether the FRAND claims in the present case are claims relating to the UK registered right. And here it's the three challenged patents. Now, in one sense, it's similar reasons than I've already submitted to you in respect to Gateway 11. And there's quite a lot of case law now in the courts below which support the position, and we've set that out in paragraphs 73 to 75 of our case. That a case such as this does relate to the registered rights.
I'm so sorry, it's completely my fault. Where are you getting the word relate to?
Oh, it's in the 6314, so on relating, I think it is.
Oh, yes, I'm so sorry.
Oh, do you have that?
Yeah, I do. Thank you very much.
So you may say it's a wider gateway than the phrase wholly or principally, but it only catches a small number of sheep. I mean, a small number of defendants, because it only catches IDPH.
We accept it only catches
Yeah.
IDPH. We're not suggesting it goes broader than that.
Yeah. And as I understand the structure of your case based on this, you say we catch IDPH and then others come in. Is this right under Gateway 3?
That's right, no. And the courts below accepted, and we say rightly that it would, IDH only can come in under Gateway 3. The only reason that we've got two interdigital companies is that IDPH is the patent owner, and then IDH gives the declaration to Etsy on behalf of the patent owner and is the licensing company within Interdigital. So we say that that is a way they have structured things internally, but we say if we're right, the claim can proceed and be served on the patent owner because it relates to their patents, then a necessary or proper party to that claim is the other interdigital party that gave the declaration on behalf of that owner. And so that's how the case is structured.
And sub 2 says a claim form rather than just a claim, presumably because it's all about service of a claim form.
I think that's,
there's no greater magic in it.
I think there's no greater magic.
Yeah.
Not that anyone has suggested. Now,
are we, when we're dealing with 6314, are we outside the serious issue to be tried?
Yeah.
You were into claim of right, a service in the jurisdiction as a claim of right, and so I think yes, we're not out. A defendant can bring a forum non-convenience stay against a claim of right case, but this is not service out with any permission necessary. It's service in as a claim of right.
I mean, if there wasn't a serious issue to be tried, they might get it struck out anyway.
Well, that's right.
As an abuse.
Right, of course it could, but one doesn't avoid that.
but
it's just maybe after the.
But it's going to a different point.
That's right.
Yeah.
Now it's said that CPR 6314 should not apply to cases such as this. I think potentially for similar reasons than I've discussed on Gateway 11. But we say it's very hard to see how a claim to be entitled to a licence under UK SEPs does not relate to those UK SEPs. And this was discussed by Lord Justice Arnold in the judgment below, where he also pointed out that it is relating to those SEPs because it also relates to infringement of those SEPs. And one sees that in the core bundle judgment, page 289. Paragraph 210. Where he explains that FRAND is commonly raised by way of defence to infringement proceedings, and we have undertaken to take a licence to Interdigital's UK SEPs on terms to be determined FRAND, and we seek a determination of what those terms would be, so that we cannot be sued for infringement of those SEPs. And he says it's impossible to say that that claim does not relate to the UK SEPs in issue, and we say that is right, and there's no reason to give relating to some form of restrictive meaning. One point that is then dealt with by the judge and is raised again by the respondents is that an approach such as this would be contrary to the decision of the Court of Appeal in Activist and Eli Lilly, and that is raised in paragraph 211 of the judgment, or dealt with in there. And I'll let my learned friend develop that, but in effect our answer to that is that that was a claim for specific declarations of non-infringement in respect not only of UK patents, but of French, German, Italian and Spanish patents. 6314 was said to apply to the whole claim, and of course upon grant, European patents granted by the European Patent Office become independent national rights. And the court held in Activist that therefore 6314 could not be used effectively to serve a claim form on claims relating to foreign patents. But we say that's not this case. The claim is not for a declaration of rights under foreign patents or a declaration on infringement under foreign patents, and that was very clear in On One Planet. It's a claim for a declaration as to whether we have a right to FRAND terms under the UK patents, and if so, those terms. So we say that that falls within 6314. As just discussed, that would bring in IDPH, and for the reasons I've already submitted, we say IDH would be a necessary or proper party. And that was the finding of Lord Justice Arnold at paragraph 213. And we say that if there is a serious question to be tried between Tesla and Interdigital as regards the Advancy 5G patent, then Advancy is also a necessary or proper party to that claim. Indeed, Advancy has said it would wish to take part, and it is only Advancy that could sign a licence in respect of that platform that includes the Interdigital patents. And that again was the finding of Mr. Justice Fancourt below at 80 and 129, although of course he found against us on serious issue to be tried. But we say that CPR 6314 does provide permission for service in, and we also commend what was said by Mr. Justice Mead on this point in Amazon and Interdigital, which my lords will find on page 1377 of the bundle.
1377?
Yes.
Thank you.
Here an argument was raised in you see from paragraph 68 that it can't have been the purpose and intent of 6314 to allow claims about proper construction and enforcement of a contract to be served on a party because it owns patents. Mr. Justice Mead at 69 explained that it's no trivial matter for a party to have patents from the jurisdiction. They choose to do so, and it makes sense that they are subject to the jurisdiction of the courts when it comes to determining the scope and effect of their monopolies. It's entirely sensible that claims about patents can be served in the jurisdiction as of right, and in a broader context, it's obviously rational for ownership of a patent in the UK to be regarded as a sufficient connection. And we say that goes with the wording of 6314, which is relating to, and this claim, we say, is a claim relating to those rights. My Lord, moving to the forum analysis, which is the fourth part of my submissions. The question in the present case is whether the case may be tried more suitably in Delaware for the interests of all the parties and the ends of justice, or here. And three issues, I think, arise on that, sub-issues. One is the characterisation of the claim. Second is availability of Delaware as a forum. And thirdly is the appropriateness of the two jurisdictions. On characterisation of the claim, or the underlying dispute, we say the analysis of Lord Justice Arnold was correct, and for the reasons I've explained, we say it is properly characterised as a dispute about whether we can have a licence on FRAN terms to UK patents and the terms of such a licence. Now, Mr. Justice Fancourt took a different view, supported by the respondents before you today, that it's a licensing claim about FRAN terms for a worldwide licence of 5G SEPs. And this goes back to the submissions I was making earlier and the discussion I had with the court. We say the difficulty with that analysis is it entirely overlooks and writes out of the characterisation any reference to a licence under UK patents, any reference to commercial certainty or uncertainty in the UK, or any reference to a desire to launch vehicles in the UK. And so we say it's overgeneralised and effectively just takes any reference to forum out of the picture. And we say that the correct analysis is whether it's raised as a defence to an infringement claim or whether it's raised prospectively to avoid a claim, is that it is a claim for a licence to UK rights or the terms of that licence. And we say otherwise it actually is overlooking a central part of the dispute and the claim that is made. Now, it's said against me that if the UK patents were revoked or did not exist or were surrendered, it would make no difference to the claim. That's Interdigital put that forward in their paragraph 114 of their written case. We say that's not right. If there were no patents here or they were surrendered, then the claim would not continue. And we say actually it illustrates that the UK patents are not just a jurisdictional device. They are the property on which we want a licence. And my learned friends for Avanci take the point in para 131 of their case that the FRAND claims are entirely severable from the UK technical patent claims.
Sorry, what was the paragraph number again?
131.
131, thank you.
And the point they make is there's no nexus between the FRAND licensing claims and the technical patent claims, so whether the patents are infringed or valid. But we say that's the wrong question. The question we say is whether the claim for a licence to the UK patents is fairly severable from whether a licence must be granted and what the terms of that licence should be to those patents. We say that isn't severable. The two go together. The undertaking attaches to the patents, which are UK patents, and permit us commercial certainty in the UK. And if my learned friends are correct on their approach, one may have a real inconsistency arising between when an implementer enforces the FRAND obligation having been sued and when they enforce it to prevent being sued. And that's a point raised by the CCIA in their intervention. That's the Computer and Communications Industry Association, paragraphs 33 to 37. Because on my learned friend's case, a SEP owner can say to an implementer and that the claim must fail or be avoided because the license on offer is global.
Could you just give me a page for that interveners?
I can. It is page 170 through to 171.
Thank you.
So turning to Delaware and whether it is an available forum to try the claim. There is a dispute between the parties as to who has the burden to show availability. And we say that where a defendant raises a forum, it has the burden to show that that is indeed available. And for that proposition, we rely on Unwide Planet and Conversant in this court on page 3027. Which was also relied on by Lord Justice Arnold. And there, at 3027, between B and C, the court explained that the challenge on forum convenience grounds requires the challenger to identify some other forum which does have jurisdiction to determine the dispute. And then even in a case where permission is required to serve out of the jurisdiction, so the burden then shifts to the claimant to show that England is the more appropriate forum. That still requires there to be another candidate with the requisite jurisdiction.
So availability means jurisdiction, does it?
Availability means it's available to try the case, and then the next question is whether or not it's clearly or distinctly more appropriate than England.
To show that it's available, you have to show that that court has jurisdiction over the claims. Is that what we're looking at, or some other?
We're looking at whether or not, in this case, it would be whether or not Delaware is available to try the claim as an alternative forum.
Available in what sense?
You can actually bring the claim there, and as I'll come on to, the issue in this case is that Delaware, we say, would not hear this claim because the courts in the United States...
But on jurisdictional grounds or some other ground?
On jurisdictional grounds, subject matter jurisdiction.
Okay.
And we say, with respect, that makes sense. A defendant can't simply just raise one or maybe multiple forums and then it's for the claimant to show they are or are not available. And we say the burden lies with them when they raise it. And then if it is available, then the burden shifts to us on the appropriateness. And that was the finding of Lord Justice Arnold. Now, the evidence below was that the US court in Delaware can hear cases over whether a SEP owner has breached its FRAND obligations in relation to its US patents. But where the parties do not agree is whether or not a US court would entertain rate setting, and in particular rate setting that goes broader than the United States. And that has never been done in the United States without consent. And the defendants have been or respondents, very careful here. They've given consent to personal jurisdiction of the court in Delaware, but they have not given consent to a rate setting globally or subject matter jurisdiction. Now, Mr. Justice Franklin...
When you're just looking at jurisdiction, what's consent got to do with it?
My Lord, if it's personal, well, it can do... there are cases where it's mattered whether or not the parties could bring the case at all there, and sometimes consent can matter to that. There was, I can't remember the name, I'll get it, about South Africa.
Generally speaking, in this country, if the court hasn't got jurisdiction, you can't confer it by consent.
You have to get through the gateways of some nature. Here in the United States, as I'll show you, the issue is whether or not the US court would entertain a claim to rate setting covering foreign patents, not whether they think it's right or not, it's a good claim or not, that it hasn't been done. And indeed, Interdigital's expert was very careful in his evidence to restrict what would happen to the US patents, as I will show you. Mr. Justice Fancourt didn't consider forum on the basis of our characterisation. And if we're right on that, then actually the evidence is one way on that, as the US Delaware court would not determine the appropriate licence terms for UK patents. And that, all the experts agreed on that, and I can show you briefly that. You can see the evidence on that. It wasn't discussed by Mr. Justice Fancourt, but if you go to our expert, which is Professor Contreras, that's in the main hearing bundle, page 637.
637?
637.
Thank you.
Yes, and sorry, my Lord Briggs's question, it was Lubber was the case I was thinking about, where jurisdiction in South Africa was conferred once they made it available by consent. And that arose in Lubber as to whether or not South Africa was an available jurisdiction. That is discussed in Amazon and ITC, but that was the case I was thinking about.
Are you going to take us there if it's necessary?
I wasn't going to, but I can do, my Lord, if...
Will you take your course for the moment? See what we get to.
Professor Contreras was page 637. Paragraph 71, where this was Tesla's expert, US expert, who said he'd understood that Tesla argued that the appropriate FRAN license for the UK patents would be global. And he explains it's unlikely a US court would adjudicate the validity of non-US patents, and he refers to a paragraph above, and that it would not unlikely to adjudicate for UK patents. Interdigital's expert was of the same evidence, perhaps stronger, and you see that at page 605 of this bundle. Mr. Kamprath, and we can pick that up at page 609, sorry. Here, he discussed it in terms of the declarations 5 and 9. I showed you declaration 5 earlier on. And his evidence was that a declaration could be brought, a case could be brought for a declaration in the US court in the terms that he set out there, which is a declaration that the terms of the SPLA, insofar as they relate to any patents in the Avanci 5G pool, which designate the United Kingdom, are not FRAND and therefore do not comply with the commitment. But he makes two important changes. One is, you see in the footnote, that he says that the reference to the United Kingdom would instead be the United States. So it only is in relation to patents in the United States. And the other thing he has removed there, as I showed you, is the other part of that declaration was for what I called rate setting, and that was the alternatively that there was a discussion with my Lord Briggs on, where we said alternatively a declaration of the terms which are FRAND for these patents, alternatively such patents owned by IDC. So the expert for Interdigital carved out what I would call rate setting, and also anything outside the United States. And we say that accords with the actual cases that one's seen, whereby it was It's only been done in the United States to date, and there's, because of the subject matter jurisdiction, and there's by consent. Avances expert, Mr. Kessler, he didn't address our characterisation of the claim at all, so he did it based on an approach to global FRAND obligations more generally, and so he didn't take into account 5G at the UK SEPs. And we say that, looked at as a whole, certainly on our characterisation of the claim, there's no evidence that says that Delaware would entertain such a claim or be available to such a claim. And if my lords aren't with me, and it is my learned friend's characterisation of the claim, we say there remains the problem of subject matter jurisdiction, and no case has done it without consent, which they have not given. Now, it's not just a case that it's never been done before. It's also a case that there are authorities saying it cannot be done without consent, and that they were discussed by Lord Justice Arnold in his judgment below, and they arise from case law from the Court of Appeals in the United States of Cordis, and about making findings in relation to foreign patents, and 2 district court decisions in Optis and Huawei and Optis and Apple, where the district court held that the foreign part of a FRAND declaration could not be permitted to proceed for concerns of subject matter jurisdiction over foreign patents. And they were discussed by Lord Justice Arnold in paragraphs 141 and 144 of his judgment, starting on page 272 of the core. And at paragraph 141, he refers to one of the first of those, the Optis and Huawei, which was a strikeout, in effect, of a claim about whether Optis had complied with its FRAND obligations worldwide. And in not permitting that to proceed, the magistrate judge, you see at 142, is quoted by Lord Justice Arnold, postulated the position as if Huawei, who was the implementer, had brought a contract claim, so the very thing that we're told that we should be doing. If the motion did not involve declaratory judgment and instead was whether supplemental jurisdiction could be exercised to resolve a claim by Huawei that the SEP owner breached its FRAND obligations, a breach of contract claim in other words, then the foreign part would be dismissed. It would require the court to decide whether Optis had breached a foreign FRAND obligation in respect of a foreign patent. And that would be similar to foreign infringement claims, and that's where they refer to the Court of Appeals in Voda. And as Lord Justice Arnold said, there's a second case, Optis and Apple, from Judge Gilstrap, which he refers to in paragraph 143, who has considerable experience of patent disputes. And the same point is raised, and we see that in the second paragraph on top of page 274. The court declines to exercise subject matter jurisdiction over any portion of count 8, which was the FRAND relief or claim, that relates to plaintiffs' FRAND obligations regarding foreign patents. And again, the judge accepted what had been said in the earlier case. And we say that entirely accords with what we saw in Interdigital's own expert evidence, where what was changed about the claim was it was nothing to do with UK patents, not a rate setting, and only US patents. And we say that in our submission means that what's going on here is that this court's being asked to say that it declined jurisdiction in favour of Delaware, where the Delaware courts have a subject matter jurisdiction issue that requires consent, and that is something that the respondents will not give. The respondents rely on a case called Continental and Nokia, which was a dismissal as a matter of law case, and there a claim was not dismissed as a matter of law. That was considered by Lord Justice Arnold, and as he pointed out in his paragraph 147, it doesn't really discuss any of the case law on subject matter jurisdiction at all. It was quite a different case because there was also a claim for a license under previous settlement agreement. And so the license claims, and the global license claims, would be proceeding in any event due to an agreement between Nokia and Continental, and so which provided for further licensing. Nothing like that arises in the present case. Now, the judge at first instance, Mr. Justice Fancourt, did not analyse the position on the basis of it being a claim about UK patent licensing, but on the basis it was a global licensing dispute. And he held that Delaware was available, but his reasoning, which is between 136 and 137 of his judgment, was not based on whether or not...
Is that paragraphs or pages?
Paragraphs. I'm sorry, the page was 336, sorry.
Thank you. Oh, is it?
And effectively...
I'm so sorry. 326, did you say?
336.
I'm so sorry, I misheard you. Thank you. Yeah.
It was 336.
Yeah, I got it.
Oh, thank you. And his reasoning actually wasn't that the US would do international rate setting. What he relied on was that the US court, and it was agreed they can determine whether or not Avanci has met its US FRAND obligations. And then he said he thought it would be surprising if the court, for instance, said it had not, so the offer was not FRAND, that it would not go on to say what was FRAND. And you see that in paragraph 137. But the difficulty with respect with that is that that is not something that any US expert said, and would, in my submission on the evidence, run in immediately to the problems of subject matter jurisdiction discussed in the Cordis and Optus decisions, and is not the approach that, for instance, Interdigital's evidence of Mr. Kessler took, and is contrary to our evidence. So we say that was not open to him on the evidence. His other point was that Tesla can't actually guarantee the English court would in the end declare the terms of a UK licence to Avanci's 5G platform to be FRAND. But subject to appeal, this appeal, we say that the reason that might not happen here is not because of jurisdiction, it's because, or that the court is not available to try the case, because our claim against Avanci would turn out to be a bad one. But that's not the reasons in the United States. The reasons there is about availability, not about whether the claim is a good one, and it's about whether or not such a claim can be brought in the United States without consent. And so we say the judge, with respect, overlooked an important element of that. And the other point overlooked is the commercial certainty of our UK launch. As I've shown you, Interdigital's expert on US law was very careful to carve out from any claim that could be brought there anything to do with the UK patents and anything to do with rate setting. And therefore, depending on what happens in the US, it may not have an effect or the effect that we would want here. And as I've said, a claim here brought by us to the English court declaring the terms for UK licence for the UK market has direct effect. And I've said from Unbar Planet, we would no longer be subject to any UK injunction threat or any other threat. And so we say that what would be wrong here is for a claim that we can advance against a patentee, for instance, here with patents in the UK market, for a licence claim as to what we need to do to be licensed on the UK market needs to go to Delaware, where, as we say, we would not be able to bring such a claim, and it would not have the effects of certainty that we have brought this claim to resolve. Now, if Delaware is, against my submissions, an available forum, we come then to the forum convenience analysis. For service out under Gateway 11, there's no dispute that Tesla has the burden to show that England is clearly or distinctly the more appropriate forum than Delaware. If service in is properly undertaken under 6314, the burden then is on IDPH to show that Delaware is clearly or distinctly more appropriate than England. And we say that if the claim is appropriate here against the patentee, it is also the appropriate to be heard in one place in relation to IDH. The only reason there's a split between those two is because one company is giving the declaration on behalf of the other. And Avanci has said that if a claim is proceeding against Interdigital anyway, it would wish to proceed here as well. Now, if we are correct on characterisation, we say the link with the UK is not casual or adventitious, to use the phraseology of Lord Lloyd-Jones in Brownlee 2. It is central. We want a licence to UK patents to get commercial certainty to launch vehicles on the UK market, and an action in Delaware would not provide that. And we say England and the English courts, the courts of England and Wales, are clearly or distinctly the most appropriate forum to try such a claim. If we're wrong on characterisation, and my lords say that this is a global licensing claim, then Lord Justice Arnold held that it would have no natural home for the reasons he gave in Nokia and Oppo. And both there in Nokia Oppo and in the judgment below, when he analysed it as a global licensing claim, he says a claim analysed in that way has no particular forum where it should be heard or is more appropriate to be heard. And if characterisation is stripped of reference to patent rights or market of launch, then Lord Justice Arnold, it would then come down to burden. So if it was on the Gateway's service out, on that analysis, we would not succeed. And if it was 6314, that analysis, we would.
Yeah.
Now, on the no natural home point, both respondents say that is wrong. We accept that for the purposes of this case, but say it's not correct necessarily for all cases. And we say that because even if one did characterise as a global licensing claim, the issue might not be one of burden. It may also there may be other connecting factors in favour of a case. In Amazon and Interdigital, Mr. Justice Mead evaluated different connecting factors between England, Switzerland and Delaware and concluded there was greater connection in England and didn't decide it just on burden. But what Lord Justice Arnold in our submission was pointing out in the present case is that the respondent's characterisation and surrounding factors don't point particularly strongly to the United States either. They rely on domicile of the first claimant and the respondents being US domiciled companies. But as he pointed out, the licence domicile in a case like this does not seem to have much connecting factor that matters in any way. And of course, the second claimant, for whom the licence would be of benefit, is a UK domiciled company with a very substantial UK business, and I've shown you the numbers on that. To the extent one's looking at business centres, all the parties are global players. There's no evidence of particular factual witnesses in the United States, and it's not a case where language or location of documents or anything like that points to one place or another. Well, and her friends point out that the majority of SEPs in the Avanci 5G platform are US SEPs, but they're not characterising the claim as a licence to US SEPs. They're saying it's global. And they also say, well, the Avanci licence agreement is under New York law and regulated and approved by the US competition authorities, but this case is not about that either. The only, actually, contract that is in issue is the ETSI.
And that's governed by French.
And that's governed by French. So we say that if we are wrong on characterisation, and one looks at connecting factors one way or the other as set out in Spiliada and other cases, Lord Justice Arnold was right. There aren't any strong connecting factors either way on a case such as the present. And of course, in Nokia and Oppo, he also pointed out that where some cases it might matter which court is determining and how it determines the dispute. And here, of course, there doesn't seem to be any dispute that the determination would be in terms of comparables, a top-down analysis, expert evidence on valuation and the like. And again, he pointed out in Nokia Oppo that doesn't point to a particular jurisdiction.
Can you help me? Did Mr. Justice Fancourt point to connecting factors?
He did, and those are the ones that Lord Justice Arnold had gone through, and I can show you Mr. Justice Fancourt did it on page 141. It's page 336, paragraph 141.
Oh, yes.
And he pointed out that he said the principal parties are all Delaware companies, although, of course, the claimant is UK, second claimant. He says the business centres are in Texas, and the majority of the SEPs are US, and I've addressed you on that. And then he looked at the Avanci licence and the MLMA agreement, being New York law, and being looked at by the antitrust. But as we say, Lord Justice Arnold correctly pointed out, that this case isn't about any of those things. And so we say that...
So, I mean, usually to challenge this sort of evaluative judgment, you need to show that the first instance judge has gone wrong in some way, in principle, yes, or has reached an irrational conclusion. How do you deal with it?
Lord Justice Arnold said where he'd gone wrong is that he had wrongly approached characterisation, he had wrongly approached burden, and he had also impermissibly mixed the risk of obtaining justice into the wrong area. You see that in, for instance, the burden, the last 2 points you see in 136 of Mr. Justice Fancourt's case. It says Tesla's case is the US is not an appropriate forum, will not set global rate, and then he, at 138, says, I conclude it has not been shown, and that is, we would say, an impermissible reversal of burden. You also see that he says in 136, I don't accept on the facts the risk is sufficient to mean that Tesla cannot obtain justice there. If what he means is the final of the Spiliada approach of whether or not we can obtain justice, it was not our case that you can't obtain justice in the United States. It was that his claim could not proceed in the United States without consent. And for those reasons, Lord Justice Arnold, we say correctly, reviewed again the approach. The other point that Lord Justice Arnold noted was that although I believe it was cited to Mr. Justice Fancourt, he did not refer to Nokia and Oppo in the Court of Appeal, which is where Lord Justice Arnold also pointed out that if the claim is going to be characterised in this general way, then it does not favour one particular party over another for the reasons I have explained.
So you don't suggest that substantial justice can't be obtained in Delaware?
We say that the claim can't proceed in Delaware for the reasons I've said. We're not putting our case on if you're looking at whether they have jurisdiction, we can't then get substantial justice in the United States. If my lords are against me and say a claim like this could be brought in the United States, then we're not saying, well, that claim would then we wouldn't be able to get substantial justice. Although, as I've submitted to you, we do say that whatever happens in the United States, it's not about justice in the United States, but when you look at where should it be appropriately tried, the result from the United States will not give us the commercial certainty here that an English judgment would, for the reasons that I have explained from Unwild Planet, and it removes any chance of an injunction.
Are you going to say anything about Harrods Buenos Aires at this stage? Because it's going to be said against you that your approach to characterization owes more to form than substance, and that if the claim was being pursued in Delaware, it would be a claim to exactly the same license or rate set, but on the basis that the rights to get that license arise out of the Delaware rather than UK patents. And there is, I think, from my recollection, at least a shadow of that dichotomy between form and substance in the Harrods case.
In the Harrods case, my Lord, I was going to address you on the Harrods case, but the Harrods case, we say a particular issue there was about the relief claimed and it being framed in an English Companies Act way. Here we say that's not, we're not in a Harrods situation because we say the very heart of this case.
Because?
The very heart of this case is a right to a license under the UK patents. It comes back to the UK patents point and clearing the way or getting commercial certainty in the UK. And that is a different point to the US, where they may look at whether or not an obligation under US law, under the US patents, has been met or not. But they don't look at the UK dimension to that, and also the agreement. Anything that comes out of the US court would not have direct effect here. It's not a relief point in the sense of Harrods about what one can do with minority shareholders or whatever. It is a more fundamental point as to we want a license to property here. We want to bring a claim to obtain that license and the right court to determine whether or not we have a right to a license to UK property and can launch vehicles in the UK market is this court. And we said that's different. That didn't arise in the Harrods case, which, again, it wasn't that once you stripped out the relief, then the Argentinian court was the more appropriate forum for that dispute. So we say they're different. And I hear my Lord says there are edges to it, but we say we're on the right side of that, because it's not about relief, it's about what it is we're requesting and what the dispute is about here. And if it's not that, then it does mean that in circumstances of frank cases, it means that it's very difficult for anyone to come to the English court and ask what license is available to launch products on the English market. And we say that is something for the English court and not something for a court somewhere else in the world. And with all these cases, the SEP owners can say, well, it's global. And then that comes back to where I started my submission this afternoon. We say that confuses the scope of the obligation with the license sought, with the patents to which it applies. So we say, on the facts of this case, on my own friend's analysis, there is no natural home. And on that assessment, we say Lord Justice Arnold was fair in how he reviewed it, and he was fair to review it, for the reasons I've explained, and goes back to how he described the issue in Nokia and Oppo. And we say, for those reasons, the claim would be more appropriate here if we are right on 6314, but Mr. Lord Justice Arnold held on if we were wrong and we were going for Gateway 11, then the claim would not proceed here on that characterisation of the claim. I do need to deal with one point that is raised by the respondents that Lord Justice Arnold accepted, it is said in his judgment, that the fundamental focus of the litigation is not the UK, and that is raised by Interdigital at 158. and they take that from paragraph 154 of his judgment on page 277 of the core. And this is a passage of the judgment. They take it from little Roman 6 on 277, where he repeats that the dispute is properly characterised as one about UK SEPs. He says, I'm prepared to accept, it could be said, the fundamental focus is not the UK, but nor is it the US. And his quote there, fundamental focus, I showed you that, that comes from the judgment of Mr. Justice Fancourt. What Lord Justice Arnold is doing here, and it starts from 150, is approaching the position if the judge is wrong and Delaware is available, what the approach then would be, and he does so on the judge's characterisation of the claim. So you see 150, he proceeds with looking at the position if Delaware is an available forum. And at 152, he explains that in those circumstances, just as he said in Nokia and Oppo, there is no natural forum to determine a dispute over the terms of a global FRAND license. So it's the if there's no natural forum. And what he's doing in 6 in our submission is showing, well, even if that is right, and even if one can then say the fundamental focus is not the UK, his point is, nor is it in the US. And so he is making the point there that if that is right, then it's not a US issue either. And that comes back to his no natural home analysis. So, my lords, we say that this case is a case that should proceed in this jurisdiction, and it either goes under Gateway 11 or 6314. And if it proceeds under 6314, we say it is clearly a case that relates to the patents here in the UK. And of course, if under 6314 on service in, the defendants then have the burden to say that there is an alternative forum which is clearly or distinctly more appropriate, we say that they cannot show that that is Delaware, even if Delaware is appropriate is available. As I've shown you, the evidence even of Interdigital is that it is not in our submission. Finally, my lord, I should deal with the procedural objections that have been raised in light of both Gateway 11 and Gateway 3. Avance's written case at paragraph 115 and I think it's paragraph 11 of the notice of objections raised an objection on Gateway 11 on the basis that it was not raised by us as part of our grounds of appeal. Now, the reason it's not a specific ground of appeal is because Mr. Justice Fancourt agreed with the reasoning in Vestel. The claims would pass through Gateway 11 had there been a question to be tried. So he was with us on Gateway 11, and that is Core 334, paragraphs 126 to 129. Gateway 11 did form part of Tesla's appeal to Court of Appeal and was addressed by Lord Justice Arnold, who held that the claims passed through Gateway 11, and that was not discussed by the majority, and that is Lord Justice Arnold's judgment, Core, page 264, paras 106 to 108. And we did refer to that in our grounds of appeal at paragraph 10, which is in page 456 of the main hearing bundle. So although there's not a specific separate ground of appeal, it is raised in the grounds. There was no finding against us on this point, and the issue was then raised by Respondents' notice by Interdigital on their ground too, and also in their cross-appeal, And we say that we're entitled to rely on the judgment of Lord Justice Arnold below in defending the position on service out. Finally, on procedural objections, Interdigital say in their para 150 of their written case, we had not appealed Gateway 3, and their reason, what they say we should have done, is they say it was found against us by Mr. Justice Fancourt, and we say that's not right. Mr. Justice Fancourt found in our favour on Gateway 3 that there had been a serious issue to be tried against IDPH, and that is his judgment at 72 and 79 and 129, which are on pages of the core bundle 323, 324, and 334. And Lord Justice Arnold agreed in respect that if there was a case going ahead against IDPH, it could then also go ahead against IDH, and that was Lord Justice Arnold at his paragraphs 213 and 220. Which one finds on page 290 and 291 of the core bundle. So we don't accept that there is any procedural problem with us relying on either Gateway 11 or Gateway 3.
So you're relying on Gateway 3 against IDH and Avanci?
We say in relation to Avanci, yes, as well, because we say not only do they accept that if a case goes on with the two interdigital parties, they would want to join that. We also say that it illustrates how they are proper parties to the claim. They are the parties that would need to sign the licence, and that's one of the reasons why they say they would wish to be part of it if it goes ahead against interdigital companies. My Lords, I've ended just a little early, but...
No complaint from us. I don't detect any further questions, Mr. Lydia. So that concludes the appellant's case.
That does.
Very good. Thank you. So I think, Mr. Nicholson, you're up next, is that right? Yes.
My Lords, Avanci only intends to address grounds 1, 2 and 5. I will be addressing your Lordships on grounds 1 and 2, and then Ms Pickard, King's Counsel, is going to address your Lordships on ground 5. I'll start with an overview as to Avanci's position, and then we'll make that good by addressing the detail on grounds 1 and 2. Now, at the outset, there are two matters which are common ground between everyone. My client, Tesla, Interdigital, and from what we can see, all of the interveners. The first point is that standardised technology, whether we're talking about the ETSI telecommunication standards or more generally, video coding, Wi-Fi and so on, standardised technology is absolutely critical to modern world. There is very little in today's technological world which has not been standardised. Broad reasons to why it's done is to enable equipment from many different manufacturers to successfully interoperate. And as a consequence, ready access to the standards by implementers is critical for the successful development in the modern age. The second point of common ground is that licensing provisions put in place by the various standard-setting organisations, the SSOs and specifically ETSI, are struggling to meet the needs of today's implementers. The SSOs generally have not created licensing portals, enabling implementers to simply purchase a single pre-packaged license covering all the steps they need to be fully licensed to implement a particular standard. Rather, what the standard-setting organisations, and specifically Etsy, have sought to ensure is a minimalistic safety net. In our written case, we have called it a fundamental guarantee, the purpose of which is to ensure that each individual SEP holder is given a contractual obligation that they are prepared to make their own SEPs available to implementers on FRAND terms. Now, from the perspective of each SSO, this ensures that the standard can't be held up, that no SEP holder can use their patent monopoly to prevent the standard being implemented. It also ensures that remuneration to the SEP holders is adequate, but not overpriced for the implementer. The practical problem is that this simple fundamental guarantee approach results in each implementer needing a license from each individual SEP holder, the so-called bilateral license. And because there are dozens of separate SEP holders, each owning a varying quantity of patent families, each implementer has to negotiate and agree with many different licensors and ends up with many different licenses. And the problem is exacerbated because many SEP holders avoid standard form licenses. They try to get the best deal they can with each implementer, meaning that every license has to be individually negotiated. And given that the worldwide licensing revenues easily run into billions of dollars, negotiations are generally protracted and hard-fought. And having fought hard over them, the resulting agreed rates are almost universally considered to be extremely confidential by both sides. That leads to little transparency in SEP licensing and makes future negotiations all the more difficult. Now, what all of this has resulted in, as I somewhat controversially termed it before the Court of Appeal, is the debacle of FRAND licensing. What I'm referring to is the familiar and never-ending stream of disputes before the world's courts, arguing about when licenses are required, how the licenses should be framed, and how much should be paid. And for many years, when parties couldn't agree to a commercial deal, the only choice was jurisdiction by jurisdiction litigation for patent infringement. Now, this court, in Unwired Planet, provided a significant positive step by recognising the jurisdiction of the UK courts to set the terms for a global FRAND licence between the parties in a single action before a single court. Now, no doubt that has assisted, but unfortunately, especially in the mobile handset arena, the debacle continues. Parties are still being dragged before the courts, and as other jurisdictions have started to follow suit, we've seen a raft of forum shopping, anti-suit injunctions, anti-suit injunctions, court-determined interim licences, and so on, as well as significant disputes even within the United Kingdom about how exactly FRAND rates should be determined by the courts. And of course, nothing in the Unwired Planet jurisdiction solves the problem of each implementer having to obtain a licence from each individual SEP holder, as my Lord Justice Kitchen referred to earlier. They didn't consider oral platform licences. The Unwired Planet jurisdiction deals with the global issue, but only on the basis of bilateral licences between a single SEP holder and a single implementer. And it is against that background that Avanci comes along with its commercial platform solution. As is set out in the Statement of Facts and Issues of paragraph 8, Avanci specifically uses the term platform in recognition that it is independent of all of the SEP holders. And for that matter, it is also independent of all of the implementers. It doesn't own any patents itself, and Avanci has not made any declarations to Etsy or any other standard-setting organisation it has entered into no obligation itself to license on FRAND terms. And it's important to keep those characteristics of my client in mind, because there are lots of different types of patent pools out there, and few are as independent as my clients, which of course is the subject matter of this case. Now, what Avanci has set about doing is to create an open market for a specific industry sector, the automotive sector, by which SEP holders and vehicle manufacturers can collectively license and effectively fix terms in a simple and comprehensive manner. And to achieve this, Avanci spent several years speaking with both sides of the industry. It then deployed its own skill and labour to draft a platform regime and collective licence, which it believed would be mutually acceptable to the majority of SEP holders and the majority of vehicle manufacturers alike. And having done its work, it launched the Avanci 5G platform in August 2023, and no doubt held its breath. If Avanci had got the structure or the rates wrong, the platform would have failed. If it was too expensive or otherwise too pro-SEP holder, the SEP holders would be keen to sign up, but few vehicle manufacturers would want the licence. Conversely, if the platform was too cheap, the implementers would sign up, but few SEP holders would be prepared to put their SEPs available on the platform. And whether the platform sinks or swims depends on Avanci getting it right, because there is no obligation on any SEP holder to join the platform, and there is no obligation on any implementer to take a platform license. Now, as it turns out, my client is very good at what it does. It approached the market with a very balanced and mutually acceptable pitch, as empirically evidenced by the take-up on both sides of the industry. The position is summarised in the Statement of Facts and Issues at paragraph 11, that in under 12 months, that's between the launch in the August of 23 and the first instance hearing in July 24, over 65 SEP holders chose to join, including most of the major names from the SEP holder industry: Ericsson, Nokia, Qualcomm, all SEP holders on the platform. Between them, this made some 170,000 SEPs available on the platform, which Lord Justice Arnold recorded in paragraph 18 of the Court of Appeal's judgment, meant that the platform then was able to license more than 90% of all 2G to 5G SEPs. On the implementer side, by the first instance hearing, 31 vehicle brands had signed up to take the platform license, including very well-known international brands such as Volkswagen, Hyundai, Kia, Mercedes, Ford and Volvo. The take-up on both sides increased by the Court of Appeal, and as of today, the platform now brings together 89 SEP holders licensing 86 vehicle brands from around the world, including the United Kingdom, mainland Europe, the United States, Japan and China. The equivalent, 86 times 89, is in excess of 7,500 bilateral licenses. And the platform license is effectively fixed price. Each manufacturer pays the same non-discriminatory price devised by my client, nominally $32 per vehicle. And the SEP holders are rewarded based on a confidential distribution system devised and administered by my client. And the result is that any automotive manufacturer anywhere in the world can obtain a single worldwide license covering their 2G to 5G connected vehicles simply by going to Avanci and paying the same price as all their competitors for the off-the-shelf platform license. And because it works, most of the automotive sector is already licensed to almost the entirety of the 2G to 5G stack, all without protracted negotiation, without either SEP holders or vehicle manufacturers being dragged through the courts, and with total transparency about what everyone is paying. And Avansi's position is that it has done exactly what the standard-setting organisations, and in particular ETSI, expected. It has assisted and enabled SEP holders and implementers alike to come to a commercial licensing arrangement which enables the implementers to access the standard on fair terms and ensures fair compensation for those who contributed their technology to the standard. It's operated against the backdrop of the fundamental guarantee, without need for anyone to enforce individual bilateral licenses on FRAND terms. Now, my client says that its platform is fair and reasonable. It says that that is empirically evidenced by the widespread voluntary adoption by both sides of the market. If it were not fair and reasonable to either side, the platform would simply have failed. And Avansi also says that its license is non-discriminatory because it offers the same transparent flat rate to each vehicle manufacturer on the same terms. But saying the Avansi platform is fair, reasonable and non-discriminatory is not the same as saying that the Avansi platform implements and discharges the specific contractual obligations of each individual SEP holder. And it doesn't mean that the Avansi license is enforceable by an implementer, whether as a substitute for the SEP holder's contractual FRAND obligations or at all. We'll look at the obligation shortly, but it is common ground that Avansi doesn't purport to discharge anyone's obligation, and each SEP holder remains under its personal obligation to be prepared to grant a bilateral license on FRAND terms in the event that any implementer wants one. But by this action, Tesla wants to take Avansi's solution away from the open market and force the entire automotive sector back into the courts. It says it should be entitled to all the benefits of a platform license, but it doesn't want to pay the open market price. It effectively contends that simply because the Avansi license is about standard essential patents, the free market is not to be trusted. My learned friend says that the court must somehow be prepared to intervene and in effect take over Avansi's role. The court must come to its own view as to what is fair and reasonable in the market, and to the extent necessary, rewrite Avansi's license to impose on both sides of the industry what the court considers to be its better view. Now, my client's fundamental position, which was accepted both at first instance and by the majority in the Court of Appeal, is that Avansi's 5G platform has nothing to do with any FRAND obligation. It is a purely commercial arrangement that exists in parallel with the fundamental guarantee. And the consequence is that there's no legal basis entitling the court to interfere with Avansi's, the SEP holders, or the implementers' freedom to contract, to reach mutually acceptable commercial agreements, and still less for the court to impose itself as effectively a regulatory body over a free market commercial contract. As held by the majority in the Court of Appeal, there is no legal obligation on anyone to get together and offer the commercially convenient platform license. And that cannot change simply because SEP holders exercising their freedom to contract decide to license through the Avansi platform alongside their contractual commitment to to offer bilateral licenses on FRAND terms. Indeed, Tesla does not now contend that any new obligation arises on either Avanci or the SEP holders as a consequence of their participation in the platform. And what that means is that Tesla has no legal right to demand a platform license from anyone. And without such a right, there is no legal basis for the courts to interfere with what is being offered. As we shall see, it was never the intention of ETSI to require the SEP holders and implementers to be continually in dispute before the courts. What the SSOs expected is that the industry will, wherever possible, reach commercial licensing deals which avoid the need to involve the courts or any other arbitral body. The role of the SSO's fundamental guarantee is a fallback to ensure that the SEP holders are obliged to play ball, that they cannot hold up the standard by refusing to grant licenses at all, or by demanding excessive royalties. The guarantee is not there to require that each and every licensing arrangement that involves the SEP is subject to supervision and regulation by the court, nor is it there to prohibit parties from reaching mutually acceptable commercial agreements without relying on their strict FRAND rights. Now, my client, of course, recognises and accepts that, as with any other commercial transaction, its platform remains subject to the general laws of the land, and most notably competition law. Avanci and those who utilise the platform cannot get themselves involved in anti-competitive practices. And indeed, Avanci specifically submitted its 5G platform to the Antitrust Division of the United States Department of Justice for competition purposes before its launch. But breach of competition law is not how Tesla brings its case. Now, I'm aware of the time. I was about to just deal with a couple of points the interveners made, but I mean, your Lordship's hands are swiftly done.
It sounds like that's a convenient moment, Mr. Nicholson. So we'll resume tomorrow at 10:30.